right, who's going to do the exhibits for the state? Hold on one second, please. Thank you, Mr. Bell. Does the state wish to offer some exhibits and evidence?
Yes, Your Honor. Erica Barnville will present that to the court.
And Your Honor, refresh my recollection. Would you like me to start with the ones that there is no objection to or that there is objection to?
The ones where you pretty much know they're not going to be objected.
Very good. That would be exhibits 1 through 13,
Okay.
16, 26
Mm-hmm.
through 26 through 102, 104 through 126, 128 through 130, 144 through 147, 149. Photos are already in, just a moment, Judge.
Sure.
Alright. 825 through 997, 999 through 1051, 1053 through 1058, 1071 through 1076, 1086 through 1178, 1180 through 1182, 1184 through 1187, 1191 through 1202, 1204 through
Sure.
1209.
Keep in mind, 1209 is already in without
sorry.
objection. Those are the texts, but it's okay.
I missed that one. Sorry, Judge. Let's see. 1222 through 1224 were the 3 exhibits that were stipulated to yesterday.
I didn't make a note of those on the exhibit sheet, but okay, 1222 through 1224?
Yes.
Okay.
1242. Your Honor, I believe I may have missed a stipulation in there someplace. Just give me 1 second. Well, I guess regardless of whether there's a stipulation in there or not, those are the ones that we are seeking without objection by the defense.
1242, you say also?
1242, yes. It's my understanding 1243 that disciplinary letters was admitted yesterday. Is that correct?
1243 was admitted yesterday,
Okay.
yes, over
Objection.
Who's handling
And then,
exhibit?
I'm sorry, Your Honor. And then we have associated the physical blow-ups. I don't know if you want me to read those in separately. Those are basically A versions of stuff that was marked that's contained within the stuff that we previously discussed.
Well, I will say this, those are not going to be part of any record transmitted on appeal. The only thing that would be transmitted to the Court of Appeals would be the original, the 8.5 by 11 or other similar sized version. So I don't think it's absolutely necessary to get an exact rendition of what I would call the A version, the enlargements of each of these right into the record, unless there's only 5 or 6.
No, there's probably 20 maybe.
Well, let me ask the defense, who's handling exhibits?
Me and Tom, but I can speak now, Judge.
Okay, did you listen, Mr. D'Angelo, to all the numbers that Ms. Barnhill just proffered?
Yes, Your Honor.
Are you confident?
Yes, Your Honor.
Are you confident you know what those items are?
Do I, Your Honor?
Yes?
Yes, I do, Your Honor.
All right, and do you object to any of them?
No, Your Honor.
All right, so all of those are admitted without objection. She has about 20 enlargements of, well, about 20 of those exhibits just discussed. Do you have any objection to those going into evidence?
No, Your Honor.
Those are admitted too. And as I think about it, I guess I do prefer to be thorough. So in a moment, we'll make a notation what those are. Now, are you proffering some that you think your opponent is going to object to, Ms. Barnhill?
Yes, Your Honor. Sort of using logical groups here. I'm going to say these will be slightly out of order, but thematically together. States Exhibits 132 through 140. 132 through 139 are Timothy Russell family photos. 140 is the ad in the Gold Clipper related to Timothy Russell. We would seek to admit those.
We would object, Your Honor.
Let me think about it. I know what they are. Let me think about it. What else do you think is going to be objected to?
Just a moment. States Exhibit 103. Which is the forensic mechanic report along with...
Mr. Smith's,
Correct.
along with?
Mr. Benya's and the audio experts, and I can just report that number here in just a moment. Mr. Maher's report in CD, which is States Exhibit 1059. Mr. Maher's supplemental report, 1060. Mr. Koenig's report in CD, 1061. Mr. Koenig's supplemental report, 1062. Mr. Beck's report in CD, 1066. Mr. Beck's supplemental report, 1067. Mr. Benya's report, 1085. Just a moment. Yes, that would be the expert reports, Your Honor.
And these are all narrative reports, correct?
They're narrative reports. The sound expert reports, as well as Mr. Benya's report, were used in both direct and cross on the Mondo pad. The sound experts in particular have charts and pictures of the waveform analysis that was done by the experts and was questioned by both the state and the defendant. I believe they should come in for that purpose.
You know what these various items are, do you not, Mr. D'Angelo?
Yes, Your Honor.
Object to any or all of them?
We object to all expert reports, Your Honor. There was testimony, and we don't think the report should come in. We're not objecting to any BCI reports, though, that relate to DNA, lab tests, sort of ballistics, examination of all those vehicles. But I think that's sort of been addressed, hasn't it, there?
Yes, that's true.
So, but the expert witness reports, the paid expert witness reports, we object to.
Objection is sustained, so 103, 1059 through 1062 inclusive, 1066, 1067, and 1085 are not admitted. Something else, Ms. Barnhill?
Yes, Your Honor, give me just a moment to catch up here. Again, States Exhibit 1188, which is the order of retraining dated 7/31/12 of Defendant Brelo that was testified to by Lieutenant Cutts, as well as Exhibits 1211 through 1220, Those would be Detective Fairchild's, from Detective Fairchild's personnel file.
What was that, Eric? I'm sorry.
The
1211
commendations,
through 1220, that's correct.
what allows 1188 into evidence, Ms. Ryan? What rule?
Your Honor, I believe it is by Mr. Brelo's comporting with that and the fact that he complied with that retraining and wasn't, we heard testimony that he was in fact retrained. I would argue that it is a admission by a party opponent by adoption.
Do you object to 1188, Mr. D'Angelo?
Yes, I do, Your Honor.
It's sustained, and do you object to 1211 through 1220?
Yes, Your Honor.
What allows those in? Fairchild, as I recall, wasn't even aware of the existence of those.
All right, we'll withdraw them, Your Honor.
All right, so I'm going to mark those not as not admitted over objection, but instead withdrawn. Are there others?
Yes, Your Honor, may I move it?
Sure.
And Your Honor, did I include, I'm sorry, I may not have it because it's next to the Fairchild stuff. Did I include the Katsaris report with the other expert reports that I sought to have admitted?
I heard 2 Maher, 2 Koenig, 2 Beck, and 1 Benya.
Okay,
And
I would
Smith.
also incorporate Katsaris with that as well. We would see to it with that.
What are you offering it as? What number?
1221, Your Honor, sorry.
Object, Mr.
Yes, Your Honor.
D'Angelo?
Same objection.
Right, it is sustained. Anything else?
Okay, all right. Your Honor, then the state would offer State's Exhibit 1227, that would be Detective Diaz's report.
Raymond Diaz,
That's correct, Your Honor.
the 7-page.
That's correct. And then,
7-page unnumbered, and
Right.
this is the number.
I remember.
and then my discussion with defense counsel prior to us going on the record was that they would not object, provided that we also admitted Detective Raynard's report in conjunction with that, and I believe that we will be doing that. We'll mark that as 1225, Your Honor.
How are you spelling Raynard?
Raynard. Badge number 279.
So, Mr. D'Angelo, any objection by the defense to 1225, Raynard's report, or 1227, Raymond Diaz's report?
No, Your Honor. 1225 is a 4-page report, Your Honor.
Both admitted without objection.
And I have just a moment, Your Honor. I think that takes care of this going in. I'll go on record for- That's it, Your Honor. That is the total of the agreement on the back of the state.
Right, and why don't we do this? Like I said, it's a little tedious, but let's get the 20 or so enlargements. Do you need a minute or two to match them up with their number, with the number of the actual exhibit, or are they marked as A already?
No, Your Honor. They're marked as A already, and they are in order by number.
Okay, do you mind then?
Sure. 182A,
Yeah.
185A,
Mm-hmm.
192A,
Mm-hmm.
193A,
Okay.
195A,
Okay.
264A,
Yep.
265A,
Gotcha.
428A,
Yep.
514A,
Mm-hmm.
798A,
Noted.
813A,
All right.
815A,
Yes, ma'am. Actually, may I interrupt you? 428, 813, 815, 1041, 1042, and 1044A are already in evidence.
very good. 819A, 1046A, 1048A, and more complicated ones. 1196, attachment R003. 1196, attachment R004. 1196, attachment R005. 1196, attachment R006. 1197, attachment O1230. 1197, attachment O1231. 1199, attachment E, 23.00.07. And then there are several that are on their own. I believe they correspond to other ones, but we'll write in under separate exhibit numbers. That is 1204, 1227, 1228, and 1242.
Meaning the things you're admitting are actually the enlargements, not a copy and a paper copy and an enlargement.
With regard to
Because 1242 is already in, for example.
1242, yes, but 1228 and 1227, as well as 1204, do have corresponding numbers lower in the exhibits. Those are blow-ups of crime scene photos that did not get named as part of an A series,
Okay.
but they are duplicates of other
Things already in
photos
it.
that are
We have a slight problem then with 12. With 1204, there already is a 1204 in evidence, and you're saying the enlargement doesn't correspond to the actual 1204?
just a moment, I'm going to just rename it.
Same with 1227, Raymond Diaz's report,
Oh, pardon me then.
and 1242. While you're looking at,
Oh, sorry.
well, while you're looking at that, Mr. D'Angelo, Ms. Barnhill read off about (22) enlargements offered as the exhibit number with an A after it. These are enlargements of things already in evidence. Do you object to the enlargements going into evidence and being used in deliberations?
No, Your Honor.
All right, so all the things you read with an A on the end, or attachment R and attachment O and attachment E, are all admitted. Now, what do you want the enlargement of 1204, what number do you want that to be? I shouldn't say the enlargement of 1204, the enlargement that you originally had labeled as 1204, but are apparently changing.
Just a moment.
Sure.
now be 1244.
Okay.
Your Honor, just for ease of the record, I'm going to name that 1227A to reduce any confusion.
Oh, is that enlargement of Diaz's report?
It is not, but it was used yesterday during Detective Diaz's testimony.
Okay.
And what was there one more? Your Honor?
Yes. 1242, you have an enlargement, but it may or may not correspond to 1242 already in evidence.
1242 was, this is as it was introduced, this was with Agent Soraya with regard to the sticky notes.
Okay, so that's already in evidence, basically. It itself, right?
Yes, as its own thing, yes, Your Honor.
So, Mr. D'Angelo, any objection to the admission into evidence of 1227A, picture of the windshield enlarged, and 1244, another enlargement coming in as actual evidence?
No, Your Honor.
Those two are admitted. Oh, and you're also offering 1228, which we didn't discuss, but that was because that was not a redundant number. You object to 1228, Mr. D'Angelo?
Is that another enlargement, Your Honor?
Yes.
No objection.
All right, so 1228 is in. So I think we have them all. The state rests then, Ms. Barnhill.
Okay. Actually, Your Honor, we would ask, we will actually withdraw the blow-ups of 1196, attachment R003, 004, and 005. Those exist on the monopad as well. We'll withdraw the physical blow-ups.
I'm sorry, Eric, what did you say at the end there? I didn't hear you.
These are on the monopad as well. We're just withdrawing the physical.
Are they part of the other exhibits that you have there?
They're part of the exhibits they were part of the cell phone.
So you're withdrawing the enlargements?
We're withdrawing the enlargements, not the underlying exhibits, correct?
We want to introduce the enlargements.
Well, we'll wait till you have a chance to you rest.
That's going to take about a quarter of the sheath.
But the problem
I was
is
thinking
they
about it.
didn't blow up. They didn't work. They work on a monoped, they don't work there.
I think he was kidding, and it's not a matter of much concern. I'll note, though, for the record, that 1196 attachments are 03, 04, and 05 are withdrawn as enlargements, but they do remain somewhere in evidence with underlying exhibit 1196. Do you rest, Ms. Barnhill, or another prosecutor, if somebody else wants to address it?
Yes, Your Honor. State of Ohio will not rest this case. Thank you.
All right, thank you, Mr. Call. Is there anything from the defendant, Mr. D'Angelo?
Yes, Your Honor.
Your Honor, we would have a motion at this time.
Under what rule?
Ohio Rule of Criminal Procedure 29A.
Please proceed.
Thank you, Your Honor, for
Just, we could give a copy of our motion also with to all the defense attorneys and counsel.
Your motion.
But thank you.
What are you handing me? A motion?
It's a written opposition status. Motion for Rule 29.
Yeah, okay. So, you know what he's going to say, I get it.
Yes, so.
You wanted to say, Mr. Shaughnessy.
Thank you, Your Honor, for please the court. Again, I would make a motion pursuant to Ohio Rule of Criminal Procedure 29A. Your Honor, as I make this motion, I'm mindful of a couple of things. One, obviously, I know that this court is well aware of the standard indicated under State v. Bridgman, and that's applicable in this motion. Secondly, Your Honor, I'm also very mindful, and you've posed the question several times, do you think I've not been listening? I know you've been listening, sir, and it is not my intention in any way to sit up here, or stand up here rather, and restate the law that I know you're aware of, and it certainly is not my intention to restate the evidence because I know the court is well aware of what each and every witness has said. Your Honor, this case boils down to two issues: causation and justification. And while I'm not going to restate the evidence because I know you've been listening, I would like to highlight just a few areas. Judge, in the causation department, the state of Ohio has not met their burden even at this stage. The state of Ohio has not produced to you identification testimony through its experts of which particular bullet or pellet ended up where. They haven't produced sufficient evidence to you under this standard of which particular bullet or which particular gun fired the shots that penetrated the Malibu. They haven't produced to you sufficient evidence under this standard that they can show which gun fired fatal shots. They haven't produced to you evidence, even under this standard, of the sequence of the shots. Judge, I'm not going to reiterate what Mr. Roberts said or what different BCI agents said, because I know the court's well aware of the lack of trajectory evidence, the lack of identification evidence, and also the other problems with the causation evidences they provided. Judge, we know the number of shots fired doesn't match the number of shell casings found. We know that the number of defects found in the Malibu do not match the number of shots fired. We know from the experts that as many as 30 pellets went through either open windows or windows that were shot out. I know the court has listened carefully and again is aware that there's been no evidence sufficient to continue on in this case based on causation regarding, again, trajectories, number of bullets fired, identification of which firearm those bullets came from, nor has there been sufficient evidence to continue on in this case of from which angle shots were received by the victims, from which gun shots were received from the victims. You heard numerous people testify that bullets came through front windows, passenger side windows, passenger side rear windows, driver's side window, driver's side rear window, and the rear window of the car. So, Judge, again, even under the State versus Bridgman standard that we're dealing with here today, the state of Ohio has not presented with you sufficient evidence regarding causation here. Judge, the next issue is justification. And I again know that the court is mindful of the law in the state of Ohio and the law in the United States of America regarding this issue, and I would like to point a few things out. First of all, even under State versus Bridgman, Judge, we have to take credible evidence and we have to take relevant evidence. And if the evidence is credible and relevant, then under Bridgman, it has to be taken at this stage of the proceedings in a light most favorable to the state of Ohio. Judge, the law on this issue is dictated by the recent opinion from the Ohio Supreme Court, State of Ohio versus White. I have the slip opinion number 2015-Ohio-492. And I know that the court is, again, well aware of this, but the issue on police use of deadly force per State versus White and per Garner versus Tennessee is a constitutional issue. And, Judge, in State versus White, we learn that what dictates this issue is the Fourth Amendment, and the Fourth Amendment probable cause standard. And courts following Tennessee versus Garner, such as the Ohio Supreme Court, in adopting State versus White, have explained that a police officer may use deadly force where the officer has probable cause to believe that the suspect poses a threat of serious physical harm either to the officers or to others. And again, in invoking Tennessee versus Garner, the court is very clear that this is a Fourth Amendment constitutional issue. The reason I bring up relevant evidence even at this stage in Rule 29 and the standard imposed by State versus Bridgman, is that the state of Ohio has not addressed that issue. The state of Ohio, through its expert witness if you want to call it that, Mr. Katsaris, did not address Fourth Amendment probable cause analysis. In fact, Judge, he sat here and he told you, he said, I can opine on police policies, procedures, and tactics. I may not opine on constitutional law questions. That's left to the court or a finder of fact. Your Honor, I would refer you back to the cross-examination of Mr. Katsaris and even some of his direct examination, and his opinion never touched the constitutional issue of probable cause. His opinion relied upon police practice, procedure, and tactical training. What he told you, Judge, was that Officer Brelo was not justified, and this was not under a Fourth Amendment constitutional standard. He told you that he was not justified in using deadly force at the conclusion of this encounter at Heritage Middle School because he had violated police tactics. We don't know what tactic. He was asked, to your report, did you attach the rule violation or the policy that Officer Brelo violated when you said that he elevated? And he said, I did not. So we don't have the police procedure or tactic that he violated from their witness, Mr. Katsaris, nor do we ever have been told that Officer Brelo was trained in that manner. Nonetheless, again, he did not analyze this under Tennessee versus Garner or under State of Ohio versus White. And what's really interesting, Judge, is Katsaris' report is dated September 25th, 2013. He was ironically a part of the White case. He, however, told you that he never followed up on White to see what the Ohio Supreme Court did with it. White was decided February 5th, 2014. Plumoff, which I'll get to in a moment, and I know the court's aware of, Plumoff versus Rickard, that also sets the standard for the United States Supreme Court in use of force cases, was decided May 27, 2014. So what we've got here is a report authored by W. Ken Katsaris a year before the landmark decisions in both the United States of America and the state of Ohio that set forth the test that has to be done in the courts of law. And that test is a Fourth Amendment probable cause as adopted in Tennessee versus Garner. Katsaris said, I never amended my report, and I didn't look at it. I didn't make any differences on it. Now, I can go through Katsaris' report, but Judge, again, all he told you was it was not objectively reasonable for Officer Brelo to take an elevated position. And why did he tell you that? He said it's not on a Fourth Amendment probable cause that they're about to cause him or somebody else bodily harm. He told you that was wrong because of two reasons. It was objectively unreasonable, which isn't the standard of probable cause under the Fourth Amendment, but rather it was objectively unreasonable based on training and tactics. And it was objectively unreasonable, according to W. Ken Katsaris, because it put Officer Brelo in danger, and it would put other officers in danger because they might have to go in and save them. He was posed the question, if Officer Brelo had fired those remaining 15 shots from behind 238, would they have been objectively reasonable? Again, not the standard here, Judge, but he was posed that question. Would those be objectively reasonable if he never left his feet? If he stayed on his feet, was his shooting objectively reasonable? And he said, I would have to say so. So again, when we look at what W. Ken Katsaris told you, he talked about a standard that may have been applicable in 2013 when he wrote it, but it certainly isn't applicable in 2015 in this courthouse. And he told you he could not opine on the constitutional question of probable cause. So when I say, Judge, relevant evidence has to be considered at this point too, if W. Ken Castaris is employing the wrong standard, then his opinion is not relative to this case. W. Ken Castaris perhaps could opine in a disciplinary hearing about whether or not you violated a procedure, again, one that hasn't been articulated to us and one that we haven't been shown that Officer Brelo was trained in. Judge, in relation to that, I would address you to several cases, both civil and criminal, in which courts have determined that a violation of policy, procedure, or training does not equal a constitutional violation. The first would be Smith versus Freeland, Freland, 954 Fed 2nd, 343. Cole versus Bone, Cole, 993 Fed 2nd, 1328. And what these cases stand for is, even if the police violated their pursuit policy and should have terminated a pursuit pursuant to that policy, an internal policy does not override the constitutional test set forward. A failure to follow a pursuit policy may result in internal discipline for the police officer, but it does not determine the constitutional test of whether the police use reasonable force when seizing fleeing suspects.
But isn't it some evidence of the reasonableness or not of the force used?
Sure. And I agree with that completely, Judge. And I absolutely follow your line of thinking. And yes, it is some evidence of the force that they used. But in this case, W. Ken Castaris never said that he used unreasonable force by continuing to shoot. He said that he used unreasonable force because he was not objectively reasonable when he elevated.
But does the state need an expert in the first place to say, quote unquote, the defendant did not have probable cause to believe that the suspect posed a threat of serious physical harm either to himself or others?
No, they don't. That's your decision. That's the fact finder.
Right. So can I, let's take your advice for the moment and put aside all of Castaris' testimony as not being relevant.
Okay.
Can't I, based on all the other facts and evidence, conclude, especially at this stage in a Rule 29 motion, that at a minimum there's a question of fact on whether the defendant had probable cause when he shot either the last bullet, the first bullet, or somewhere in between, to believe that the suspect posed a threat of serious physical harm to him or others? By way of example, and don't get me wrong, I'm not trying to preview a verdict by any means.
It's fine.
But Castaris' basic theory seems to be, although I think you're right, he didn't necessarily say as much, but I have to reread his testimony. His basic theory seems to be that of the around 139 shots taken, about 124 of them, he didn't say this, were taken by a person who had probable cause to believe that they were confronting a threat of serious physical harm to them or others. Basically, that they were justified.
Yes, sir.
Do you follow me so far?
I do, sir.
Can I conclude from all the evidence then that basically that's correct, that much of the firing that went on was justified, but that some shots were based on the evidence, not on Castaris, that some shots were taken without probable cause to believe that when they were taken, the suspect or suspects posed a threat of serious physical harm to the shooter or to others?
Yes, you may.
Then how can I grant this motion? Because I think there's an issue of fact on whether, and by the way, you have the other prong to your motion, but assuming for our argument here, let's say that there's sufficient evidence of causation
I understand.
to survive the motion. Two things. First of all, I think justification is a question of fact. Second, I'm not sure I know the answer to this, because a police shooting is different. Police are privileged in certain circumstances to fire at people. But is it the state's burden in this case, or in any similar case where a police officer in the line of duty is accused of killing, is it the state's duty to negate justification in its portion of the case? In other words, isn't that an affirmative defense?
I would concur with the court in that analysis. If I may, Judge?
Please, yeah.
The purpose of the argument that I was making regarding the misuse of the standard by Castaris, as opposed to what the current law is under White, Plumoff, and Garner, is that while the court is free, and I'll agree with W. Ken Castaris on this, and I'll agree with the United States Supreme Court, and I'll agree with the Ohio Supreme Court, is it's for the fact finder to determine under Fourth Amendment reasonableness whether or not the officer had probable cause to believe that he or somebody else was in danger of bodily harm. That's your call. What I'm suggesting to the court is that W. Ken Castaris' expert opinion should not be considered in making that determination. It should not be relied upon, even in Rule 29, because he uses a reasonable officer standard in regards to tactics and training.
Right.
And we know, so I'm just saying...
Well, I don't want to say right, meaning I necessarily agree with you. But for this argument, let's say I agree with you.
Okay.
So let's strike his entire testimony. Let's put it aside.
All I was trying to do.
Much of his testimony was summarized or alluded to facts that are otherwise of record.
Correct.
Can't I look at those facts as the finder of fact and at this point, especially in a light most favorable to the state, conclude, if I have to, because that's the second part of my question I already asked you, but conclude that at a minimum there's an issue of fact on whether the defendant was justified because he had probable cause, etc.
I would agree, Your Honor, that the question of whether or not, setting aside Castaris for purposes of our discussion, I would concur with the court that the question of whether or not Officer Brelo maintained probable cause throughout the shooting is a question of fact for the fact finder.
And then what about the question of whether it's the state's obligation in its portion of the case to negate what I think is, if not literally, it is essentially an affirmative defensive justification. For example, what if this were a plain old murder case where during the state's presentation the defendant has cross-examined witnesses clearly intending to establish self-defense, but isn't that something the defendant has to do? In other words, can you, at the end of the state's case, in another murder case, can you make the same motion and say it's clear they haven't negated self-defense?
I don't know that I can agree with that. I can say that Officer Brelo's perceptions, beliefs, and probable cause have already been admitted into evidence.
No, I agree, but remember, here I have to look at the evidence in the light most favorable to the state. And, right, you could, let's say this motion were denied in its entirety. I could then ask if you have any witnesses, and you could rest. Right. Then we have, of course, a different thing. You might rest confident that the evidence already admitted supports justification. But it doesn't mean, I don't think that the state has to negate justification in its portion of the case. But I ask the question sincerely because, as I said, a police shooting is different. Police, unlike just about anybody else, have many occasions where they're privileged to shoot, where, let's be honest, they're privileged to kill. The rest of us don't have those. Well, the rest of us have self-defense, but how should I put it? We only have that as a factual matter if we're accused of murder. I may not be articulating the distinction as well as I hope to, but the point is, police are given guns with the notion that they're from time to time going to have to use them and are going to be justified in using them. As a result, does there somehow exist when a police officer who was given a gun by his employer, by the executive branch of government, and told to use it when necessary, when he is charged with a killing, murder on down, voluntary manslaughter included, does the state then have the burden in its case, unlike an ordinary murder, to negate justification? And I don't know the answer to that. I think the answer is no, but I haven't found law one way or the other, to be honest.
I have not seen any law on that issue.
I interrupted you. I asked some questions you wanted to say, or you were saying.
Judge, I was just continuing, and I think for purposes of argument, our discussion has taken us there. I do not believe that based on the standard, and again, Katsaris, and I understand the court is free to make a factual finding on probable cause absent an expert opinion, but I am just suggesting that based on the misuse of the standard by Katsaris, his ultimate opinion should not be considered by the court at any stage of this case. And I'll probably reiterate it at another point if we get to that stage of the case. But again, his opinion was based upon tactics and procedure. And as I was stating, under Freeland, also Scott versus Henrich, Henrich, violation of police procedures has no relevance on the constitutional question of whether the police had probable cause to believe that a suspect posed a threat of death or great bodily harm to the police at the time the police fired their weapons. That's also found in Richardson versus McGriff, Your Honor, MC, capital Griff, 361 Maryland, 437.
Was that the crime dog? Was he actually a defendant in the case?
Actually,
I hope not. He would pose the justification defense, right?
Right.
He's given a gun.
there they ruled that the police officer's violation of department regulations prior to the use of force has no relevance on the issue of whether the police used excessive force. So, Your Honor, there's a litany of cases that deal with the issue that W. Ken Kastaris opined on, and again, he opined that Officer Brelo violated a police training tactic or procedure that we have not seen, that we do not know he was trained in, and even if a police procedure or tactic was violated, that does not equate to the constitutional violation. And I would just refer again to the last page of Katsaris' opinion. As for Officer Brelo's final actions, I cannot support his actions because of the egregious policy procedure and tactical training compromises. It does not say based on any probable cause or lack of probable cause. Judge, and I do think that you have the ability in any case, and certainly in a case tried to the court, to direct a verdict at this stage if you find that there is not sufficient evidence to go forward. When we're talking about this probable cause, we know from the evidence, and again, I know you've listened carefully, and I'm not going to reiterate it, but we know that Katsaris, the Cuyahoga County Prosecutor's Office, the Ohio Attorney General's, you've got numerous shooters, and they've all been ruled justified. You've got numerous shots, and all but a small portion at the end have been ruled justified. Katsaris, again, under a standard that might be applicable in a disciplinary proceeding, says that he's objectively unreasonable at the end because he put himself in danger and he would have put another officer in danger by him getting harmed himself. Well, that begs the question, it comes all the way around. If there was no probable cause to continue firing and the harm was over, then W. Ken Katsaris couldn't say that Brelo would have put himself in danger by getting up there. And if he wouldn't put himself in danger by getting up there, then he certainly would have been endangering another officer that would have to come to rescue him from his peril. Judge, we know the timeline, and you've heard it. You've listened to the audio from the Brelo dash cam. We know that even in spite of the training alleged violation, which we don't concur with, but that's what Katsar says, that Officer Brelo was given probable cause and justification to shoot from inside the car, from around the back of the car. Officer Sobolik was given that same justification. We know that during that dash cam that there's a final 18 shots, and we know that during those final 18, I believe on 4, 6, and 7, if I'm correct, there are also 3 accompanying shots that, according to the government's experts, that come from 1 to 3 additional weapons. So we know Officer Sobolik still perceived that threat or danger because he got himself moving up, getting out of the sight line, not in an attempt to hide, not because it was over, but because he was putting himself in a position to take another shot. And he would have gotten it off if he could have. So we know Sobolik still perceived the same probable cause. We know that 1 to 3 other shooters during that last series of shots still perceived the same probable cause. We know that other officers continued to perceive that it was ongoing. So, Judge, I do think that you have the ability at this stage to make those findings and direct a verdict. Judge, I know you talked about it earlier today. I know you're aware that under White, reasonable mistaken belief is valid. We talked about that quite a bit. There's been discussion back and forth, and I think you stepped in earlier today. Was there a gun? Wasn't there a gun? Was there a mistake? And I think you said, well, your expert says that there is a mistaken belief. I know that the court's aware that under State versus White, that a reasonable mistaken belief is sufficient and does not negate any type of defense. Judge, as you indicated a few minutes ago, police officers are armed with firearms. They are required to use firearms in their regular course and scope of duty. I know we had filed a previous motion on this issue regarding the firearm specifications for a pretrial ruling under State versus White that those should be dismissed. The court issued a ruling in that indicating that under State versus White that some testimony would have to be taken first. In order to sustain a firearm specification under State versus White for a police officer, there has to be proof that there was a departure from the course and scope of his official duties, not a mere mistake or misbelief of probable cause. So, Judge, on a number of issues, again, the State has not given you sufficient evidence under causation for all the reasons that you've heard. The State has not given you sufficient evidence under justification. And again, Casares' report, while the court is free to make its determination on probable cause, Casares' report does not incorporate the applicable standards under White and Garner. And thirdly, Judge, there's no evidence of a departure of the scope and course of official duties to sustain the firearm specifications beyond this point.
You are making then first a motion for a directed verdict on both counts in their entirety.
Absolutely.
And in the alternative on the firearm specs only.
Correct.
Is there anything else you wanted to say?
Judge, I just would like to just alert you back to two of the cases that I mentioned. Plumoff versus Rickard. And in Plumoff, They also adopt the Tennessee versus Garner statute or principle, and it's indicated this would be a different case if petitioners had initiated a second round of shots after an additional round had clearly incapacitated Rickard and had ended any threat of continued flight, or if Rickard had clearly given himself up. And I would just ask the court to direct its attention back to Plumoff versus Rickard and the facts there. And further, Your Honor, I do have a Jones versus City of Albertville. This is a trial court opinion, but it has a very detailed analysis. It's 102-814 ALNDC, CV-12-S-96-Northeast, and I would present a copy of this to the court for your review as well regarding this issue.
Thank you.
And Judge, further,
Will we have a copy, Ron?
yeah. Further, Your Honor, I would, while we've had discussions here regarding the burden going forward, we would, for the record, argue that it's our belief that the state of Ohio has to make a prima facie case of lack of probable cause, even in their case in chief. And that's probable cause to believe, again, that the officer is in danger or others are in danger of bodily harm or death.
All right, thank you, Mr. Shaughnessy. And I will say that if I occasionally chide a lawyer for repeating him or herself, that typically will only be in questioning when I keep hearing the same question over and over. You're pretty much, and this goes with the state too, welcome to say what you want in connection with the legal and factual argument. You know, obviously within the bounds of the rules. And speaking of kidding, I was kidding Mr. Chalupka when I mentioned before Mr. Shaughnessy's argument that it appears you already know what he's going to say. You could have reasonably expected a Rule 29 motion, and you could have reasonably inferred what arguments were going to be made. So I'm not in some way demeaning you by noting that you filed if it's been filed, that you prepared at least your brief and out before the motion was made. In fact, I have to say I appreciate it. I prefer to have something in writing. Having said that, do you want to rest on your written opposition, or do you want oral opposition as well? Mr. Bell.
Short oral opposition, Your Honor. The intent of the motion was to be able to cut through a lot of the legal issues so we could provide it to the court in writing. So
I'm sincere when I say I prefer to have it than not have it.
Thank you, Your Honor. At the court's ready, I'm ready.
Yeah, please.
Thank you very much. Your Honor knows the standard Bridgman, Jenks, Tompkins. We have a burden at this point to show that the court, in a light most favorable to our case, that this court or any rational trier fact would have found the essential elements of the crimes proven beyond a reasonable doubt. And Mr. Shaughnessy is concentrated on causation. The court has heard the other elements as well. I will not go through each of those because the court has been noted to take copious notes and had eye contact and provided both parties with 2 weeks and 2.5 days now of complete court time, and all of us thank you for that. So, Judge, I was going to talk about causation first. I would like to go into justification to answer some of your questions first, because that's where we left off with Mr. Shaughnessy. I would like to say that I believe that argument that was posed to the court, that is, that Mr. Caceres' testimony was somehow flawed or inadequate or should not be even considered. I believe that the defense at this point has set up what I would call a straw man argument to that. That is, first of all, the court properly, I believe, asked questions about whether or not an expert is even necessary. There have been many cases where experts haven't been called, and that is true, that an expert is not necessary. But the state wished to bring that evidence to the court so the court would have that ability to review the constitutionality. Now, when Mr. Caceres says that he's not opining on the constitutionality for the court, and he turned to the court, it's because he knows that the court is the trier of fact. He's not commenting on the ultimate decision of the court, because he knows as an expert that that is something beyond his purview. That is the court's purview, whether or not there's probable cause or not. He wasn't just testifying about tactics and procedures. We didn't call a tactics and procedures person, which we could have done through any number of different officers, including the academy officer when we had Lieutenant Cutts coming. He was called in order to testify about justification in our case in chief, because there isn't much law on that, whether or not it's required or not. But we wanted to make sure that we checked that off the list to show the court that the evidence was such that the defendant was not acting reasonably and was not justified in his actions. We also didn't want to go over bounds. If we had somehow had him testify as to the law, we'd be making him into essentially the uber expert and putting him in the place of the trier of fact. So knowing that, the state did not ask him the ultimate issue of fact, which is in the court's hands. That is, was the defendant acting reasonably? Was he justified in his actions at the time that he got on top of the trunk and then actually elevated secondly to the light bar and then jumped over, still in an elevated position, onto the hood of the Malibu? All of that is a probable cause determination. It's for the court. And when you do those determinations, you look at the totality of the circumstances. The objective reasonableness is determined by the totality of the circumstances. That would have been done by the 12 jurors or would be done by the court, not by an expert that would say this is the way that you should rule or this is what the verdict should be, or even the Constitution has been violated or something. If there had been, Judge, there would have been an objection, because we would have been putting a legal expert on to explain what the law is, and certainly the court knows that there have been objections to other opinions or other expert reports that we've had. I think in this situation, Judge, when you're reviewing the case and the case law, Tennessee v. Garner has been around a long time. Plumoff v. Rickard takes Tennessee v. Garner, and it says that the law still applies. When you look at the White decision, it takes Tennessee v. Garner. The standard is still the standard. It is the same. So he's wrong to suggest here to the court that somehow there has to be an expert opinion that's provided. And the court is correct. We could have gone forward even without Mr. Caceres and let the trier of fact decide on the totality of the circumstances as to Defendant Brelo's reasonableness or not. He didn't use the wrong standard. He did not just opine on tactics and procedures as was brought here. Now, Your Honor, as to the issue here of causation, and the court knows that causation is an element, of course. The defendant's identity on the hood of the Malibu, the state wanted to make sure the court understood that we have evidence not just from the eyewitness, Officer Cebolic, who was in prime position to see him when he came out of his cruiser and came around to a position of cover and proceeded forth from that position of cover, shooting to go to the next position of cover, which, by the way, was on the other side of 238 to remind the court of that testimony. But specifically, Judge, the blown-up exhibit in front of you, you'll see that Officer Cebolic, as he testified here for court with his back turned towards the wall back there, explained that there are two hands on the gun. It's not one. It's in a firing position, as they're taught, as they're trained, as Agent Sarai has explained. And he's pointing downward, Your Honor, and the position is a steep angle, which is important because when you look at the position on top of the hood, that would place him in a position of point-blank range. He has got to only be 2 feet from the inside of the windshield, perhaps, where the occupants were to the windshield, and another 2, 3, or maybe 4 feet at most. And the position is in such a steep angle, you can see that it's in a position that he would have had a very clear view and a very close view. It strains credulity to believe that he would miss in a position like that his targets when he's a trained officer and trained to shoot, as the other officers are in groupings, in the mass groupings in the chest. And it's, in fact, that's what we have, the downward trajectories into the bodies, Your Honor. Can I have that, the causation chart? Please, Your Honors, I would argue to the different triers of fact, whoever, go by your notes and the testimony that's available. But in reviewing that testimony, my notes and transcripts, I did take the opportunity to put together, which is in the court's filing here, the motion in front of the court, the different wounds and different bullet holes, if you will, the wounds of the bodies that were testified to. So we know that Officer Brelo shot 49 to 50 total rounds. That's something that's known, if he had that extra one in his magazine or not. But 49 were in fact found. All 49 go back to his gun. And he shot 17 rounds from his second magazine, we know that, with the 15 rounds from his third magazine, because only 2 were left. So that's a total of 32 the state would pose to you that are shot from an elevated position. Because when you take that in conjunction with his statement where he says, Your Honor, that he shot or that he reloaded when he hit the bumper or got to the bumper of the car, anything from that point forward, as Mr. Caceres said, is an unreasonable position. It's unreasonable for him to shoot from there, placing his life and the lives of his fellow officers in danger at that time. So when he did that, there would be possibly 32 rounds all fired from that elevated position, Your Honor. 27 of his casings can be found by a simple count of the red casings on the diagram, which will be in front of the court. 27 consistent in the areas where you'll see, as the court has seen a number of times from the diagram, off to the right in an arc, and from Agent Soraya's testimony, even backwards, usually, mostly. You've heard other testimony that you can't always say where the casings go. We brought that out so the court would have that testimony. But there comes a point in time when you have so many shots and so many casings dropping that there's a clear common sense indication of where they're going. Not just generally, but when you get to that, to the point where you have 27 different casings all falling in the same area, especially when you know that there's a wall, if you will, or there's an object that's preventing them from bouncing back. When you see the red in here and you count the casings that are attributed to an upward elevated position, if you know if he was back here behind the bumper, they'd be coming off and to the right, perhaps a few up front, but not like this that you have here. And so from an upward elevated position going off in an arc, you see a large area of casings. And if you count up these casings, there are 27 there. Very significant because, as Dr. Philo testified, Your Honor, there are 28 total downward trajectories into the bodies of Timothy Russell and Malissa Williams. Those 28 trajectories, they're in a steep anatomical position, Your Honor, and when we placed for demonstration purposes the mannequins in the car, it's to not only give us the idea of where they were coming from and how they might look and coordinate with the bullet holes in the windshield, but also to give any reviewer, whether it's grand jury or whether it's a trier of fact, the understanding that these tight groupings match up to tight groupings that are on their bodies. That is, they're in that position where they're down, they're low, as the court has seen from the different pictures from the cell phones, that were not disturbed, the state would argue, that the bodies in those different photographs from the Eric cell phone as well as the cell phone picture that was sent to him, or he sent to Officer O'Donnell, as well as pictures from Cleveland Police Department and the coroner's or medical examiner's office, show that those bodies were not disturbed. So they're in that position where they're down, they're low, and they're certainly underneath. And it's the reason, isn't it, why Officer Brelo says that he had to jump up there, because he wanted, the engine block is in the way, right? And he wants to be able to get up, and he wants to be able to continue to shoot. So he puts himself in that spot rather than going off to the left, and you have that totality of circumstances, the factual arguments that were made. There are other people that are over here down the hill who could very easily have come and stayed in that position of cover, as all of the others did. And when you look at that as a totality of circumstances and argument, that shows you the training and the reasonableness by all the other officers. You've got 13 officers here, 12 of which maintained positions of cover or tried to, or they said that they wanted to. If they came out, they were running to a position of cover. And he put himself in that position. That goes back, now I'm sorry for moving from causation back into reasonableness, but as I'm going here, I think that's something for the court to consider. It's not reasonable for him to have done that, placed himself in that in danger. But there's 28 downward trajectories. There's 27 of his casings that are found over in that area, which are consistent with positioning of the casings falling back to the right as an arc. And because of the position of the three cars, they're relatively contained. Now, can somebody kick? Can somebody move? When he got off, might something have changed? But that's what's significant here, is that the plurality of these, the multiple casings, show you that things really haven't changed or could possibly change that much. So you've got the downward trajectories of the bodies, and you have the casings that are there. And when we look at the bullet holes, Your Honor, and I'm specifically going through the chart, and again, please use your notes better than my personal review, but from the notes, from the transcripts, and again, in light most favorable to the state, but attempting to be conservative here, the downward alive fatal shots. And as you see, there are 15 downward trajectories, as Dr. Philo testified, and Timothy Russell and Malissa Williams. 15 for Timothy Russell, 13 for Malissa, and I believe it's with an A anyways, I think, in the coroner's reports.
It's a minor thing, but I've always wondered about that.
It's been a curiosity from me myself, Your Honor, but we took one of the official reports initially, and it might be the coroner's report from that spot. But the 15 downward trajectory, by the way, my wife's name, is it IE or a Y on the end? It's always different, everything. But in any event, 15 downward trajectories with the different wounds for Timothy Russell. 13 downward trajectories, and that's why Dr. Philo said that there's 28, 15, and 13. And we actually went through them painstakingly, which we wanted to make a good record for the court, but we have the different wounds of those downward trajectories. And there can be some argument over whether something is downward or not, or what the positioning of a head was or not. But in the downward trajectories, in counting through his testimony, 1, 2, 6, 7, 8, they're on the board with the court in the motion. I won't go through them all. But 11 of those, Timothy Russell's 15 downward trajectories, are alive shots, ante-mortem wounds, or as there was testimony, the body was alive at the time. And of those 11, all 11 were fatal wounds: 1, 2, 6, 15B, C, E, F, G, H, and I. And also, when we look at Malissa Williams, 13 downward trajectories, wounds 8, 9, 10, 11, 12, and also in the 8 perforating wounds that were all together, making 13. 16 of which were able to be determined that Malissa Williams was alive. The testimony was not that the others were all post-mortem, just that here you know that these were specific life was in these shots. And then specifically there are 6 fatal wounds in the vein that the testimony at this point in time. 8, 9, 10, 11, 12, and 13. We've got the last two, 12 and 13, as the court remembers, have a slight upward movement, one here, but given the shifting of the body as the coroner testified. But 4 or 6 of those 6 ante-mortem wounds, live wounds, are all from that downward trajectory. So that box is just the downwards. And again, it's in order to explain why the state believes that all of this evidence working together, the totality of the circumstances, is something that can be relied on by the court. And then for the court's knowledge, just so we have put down, we have the total wounds in which they were alive and the total wounds, the total fatal wounds in each victim. So Judge, the causation, we believe, is clear that the defendant himself was in this point-blank range where he's been trained, where he's shooting in groupings and he's shooting down in there. And the court will have the case law in our motion here regarding contribution of death. That's why we ask the questions about that. And the hastening of death. Because an offender who's inflicted injuries capable of causing death cannot escape culpability, as the court will read in the motion, for homicide simply because there are intervening assailants that have inflicted injuries that also contributed to the victim's death. As well, Your Honor, that's State versus Lamar in the motion. And also State versus Keene. There can be more than one actual killer and thus more than one principal offender. And then it explains how there can be multiple gunshot wounds. Now, the coroner's reports themselves explain death by multiple gunshot wounds. And lastly, the evidence in the instant case, in the Phillips case, they stated clearly demonstrates that appellant, that is the defendant in that case, the Phillips case, hastened the victim's death. Having done so, appellant cannot escape criminal liability by arguing that the victim was going to die anyways. All of that were thoughts, and we wanted to make sure that the court was aware of in case there was any type of question about causation and the contribution of death, the fact that there are multiple shooters here. So, Judge, the rest is there in the motion. I don't wish to labor this anymore. I thank you for giving us the time to speak to you. Thank you very much.
Yeah, how about the alternative motion to dismiss the specs only?
Yes, Your Honor. We rest on the brief there, as the court will see, and the court made the correct inquiries with Mr. Shaughnessy regarding the scope. The fact of the matter is that Mr. Brelo here, the defendant, was still shooting, and he was shooting in an unreasonable position. Once he does get up on top of the trunk in that position, and also on the light bar, and also on the hood, he's no longer acting under the scope and authority that he's supposed to do. Thank you.
Well, from your argument, though, Mr. Bell, that any police shooting would justify the imposition of the firearms spec. Because, of course, if a police officer is ultimately found guilty of the underlying crime, a murder, here voluntary manslaughter, murder B, what have you, he will have necessarily deviated from his duty by committing that crime. Yet the Supreme Court didn't exactly say that. The Supreme Court, and I'm talking about the Supreme Court of Ohio at this point, Here, give me a moment if you would. Here at paragraph 72, Chief Justice O'Connor says, what if a jury finds that criminal liability attaches for a police officer's use of excessive force for something less than intentional criminal activity, such as an officer's mistaken judgment regarding the need to use the firearm? What if the jury determines that the use of the firearm was not justified under any circumstances? And then, in other words, that's going to be the case here. If he's justified, then, of course, the spec goes anyway. But if he's not justified, if he's found guilty of the underlying offense, according to her, the question then becomes whether the spec would apply. And then she goes on to note that in that case, White is subject to criminal liability based on an allegation of unreasonable force arising from a mistaken decision while engaging in his law enforcement duties. We don't have as complete a factual record of what happened in White as we do here, but the basic facts in White were that a motorcycle was pulled over for some traffic violation. As the officer got out, I think he had unholstered his gun. I think he had his gun at the ready, but not up. As he approached the motorcyclist, he saw his arm move and he shot him. And he was later convicted, I think, of felonious assault. So there, and there the officer, as here, essentially claimed that he was that he was justified in using force because he had probable cause to believe that the motorcyclist in that case presented a threat of serious physical harm to him or others, which, as you can see, is basically going to be the same claim made here. There, Chief Justice O'Connor goes on to say there is no allegation that White, let's say Brelo here, abandoned his employment and intentionally engaged in criminal conduct. What she's referring to there is the majority opinion's earlier recitation of examples of intentional criminal conduct that might justify the finding on the spec, the application of the spec and then a guilty finding on it. Those include, for example, at paragraph 36, a police officer who robs a drug dealer at gunpoint. Here, the majority opinion said someone who does that would subject themselves to a firearm spec because they have voluntarily chosen to engage in criminal activity. And then back to Chief Justice O'Connor's concurrence, she, and if you'll bear with me for a moment while I find her exact language, she says, as part of his employment, White, Brelo here, like other similarly situated police officers, was required to carry and use a firearm if necessary. He did not carry or use his firearm to facilitate a criminal offense. Instead, he used it in an attempt to do his job. Even Katsaris agrees that he used the firearm that night in an attempt to do his job. So is this really the kind of case like, for example, going out and robbing a drug dealer where the Supreme Court contemplates that a spec can, and let's put aside finding him guilty on it, but can be applied in the first place?
Yeah. But Judge, I think that the Supreme Court gave some clear examples. I don't think that precludes any trier of fact at this point from drawing a reasonable inference that he did in fact abandon his official duties. The standard, if you will, there, they explain that the firearm specification may apply if the facts of a given case demonstrate that the actions of the officer display criminal misconduct that constitutes a departure from the course and scope of his official duties, as police officers have no license to commit crimes under the color of the office. But what you have here is specific facts that say that he was reloading at the time. He left that cover. He stopped using official duties, official training, when he got up on the hood of the car and in the trunk, and he continued to shoot. So at some point in time, he no longer is shooting as a police officer. At some point in time, he abandons the training to such an extent, Judge, that he's committing the crime. Here, we're not just saying that he committed a crime, but we're saying he committed the crime, and when he did so because he was not acting as a police officer anymore. Simply, it's the facts are so egregious, and the reloading and thinking while he's reloading that he has to reload. That is something that is for this court. And at this time, at Rule 29, given the inferences, the reasonable inferences that can be drawn in the light most favorable to the state would ask that you retain those facts. And two more.
Well, the other thing the Supreme Court said was, regardless of the reasonableness of White's belief that McCoskey was pulling a weapon and that his life and his partner's life were in danger. So here you can say, regardless of the reasonableness of Brelo's belief that Russell and or Williams endangered his or his colleagues' lives. The Supreme Court says White, Brelo here, acted as a police officer throughout the incident. In other words, even when White was committing a felonious assault, was shooting the guy. Isn't that the same? Isn't that analogous? If not identical, there is a different number of shots, that's for sure. But isn't it almost as analogous as you could get?
Well, Judge, I don't think that at this point in time, when you're reviewing the facts on this standard, that it is the appropriate time to take out a firearm specification here. Because you have a situation where he is, in fact, their evidence is, in fact, there that his conduct is as egregious as it is.
Do you see any factual scenario based on the record evidence, and if these motions are denied, the evidence you reasonably expect to come, where the defendant can be found guilty of both the underlying offenses but not guilty of the firearm spec?
Do I see that as a possibility?
Do you see that right? I mean, and I'm not asking to admit that he might be. I'm saying, considering all the facts, would such a result be, depending on what evidence was believed, could it be correct even as a matter of fact, not to mention law?
I think it could be a matter of, it's not, conversely, Judge, I don't think it's axiomatic that the firearm spec applies. I think the court can make, as the trier of fact, when they're reviewing the guilt or not guilt of the defendant, can make the decision whether or not that evidence is present. So you don't need necessarily, just because he's committing the underlying fact, that the firearm specifications are retained at that point. Is there sufficient evidence? I believe that there is sufficient evidence, but I don't believe.
I'm not asking you to give up some argument that he should be held to account for the spec, not to mention the underlying offenses. I'm just asking you to, whether as an academic matter you might say, a certain verdict is possible. And I guess you're saying that depending on what the finder of fact concludes the facts actually are, I guess you're saying that there is a possibility.
Yes, Judge. There are two separate determinations to be made.
All right. Thank you, Mr. Bell.
You just had one further request.
Well, can we go off the record for 1 minute? Do you find, Mr. Court Reporter?
Yeah.
All right, so we'll go back on the record. You want to, what, add to the motion and argue?
We just wanted to add, if necessary, by reading their cases. We haven't read their cases. If we could read them, we could respond by 5 o'clock.
Well, I'll tell you, I haven't read them either. I've read some of them, but not all of them. So I'll give you an opportunity for rebuttal argument, but before you do that, whether it's 5 minutes or 20, or whatever it's going to be, I believe I need to think about these motions. In other words, clearly I'm going to rule on them, but I'm not necessarily going to rule as soon as you say your last word, Mr. Shaughnessy. Given that, is there any, and you know we're off tomorrow, well, no matter the outcome of these motions. I just want to say this, I'm not going to rule orally before we leave here sometime between 4 and 4:30 today. However, it is of course possible these motions could be denied. I'm going to ask that the defendant be ready at 9 o'clock on Friday morning to present a witness. Now, having said that, do you have any non-expert witnesses you would be ready to present for roughly 3 hours on Friday? Because I've told you I can't be here in the afternoon.
No, Your Honor, we intend to move forward, and if, depending on the court's ruling, we have to move forward, we will present expert testimony. And
but I'm asking on Friday morning, let me put it this way. Can you come here Friday morning, not knowing the outcome of the motion? Of course, the worst that happens is your motion is granted and your witness has to go home. But can you come here Friday morning prepared to put on about 3 hours of testimony?
No, Your Honor, we were reserving the right, let me put it to you this way. Based on the state of the evidence, we don't see a need to call some of the witnesses we were planning on calling, other than the experts. And we reserve the right, of course, to deal with the issue of our client at the appropriate time.
Well, that's what I'm driving at, because I told you I wouldn't hold you to have an expert here this week. I can't go back on my word on that. What you're telling me then is that, except for possibly the defendant, if these motions are denied, you don't expect anything other than expert witnesses?
Correct, Your Honor.
Okay. So when we conclude here today, then we should plan on reconvening Monday morning, April 27th at 9 o'clock, and you should have your first witness ready. And like I said, of course, if the motion winds up, if you're informed that morning that it's granted, I can't imagine you'll be disappointed, but you will have incurred some probably expense and inconvenience. If it's not granted, if they are not granted, I should say, you'll be ready to go.
So then, Your Honor, we have a chance then to respond by tomorrow or something with
You're welcome.
these other cases to supplement our brief?
You're welcome to file whatever you want. Just make sure you get it to the other side, too.
Sure.
Right, so we'll give the final oral word to Mr. Shaughnessy. Before we do that, we'll go off for a second. Do you have a rough estimate?
Actually, no, that's 4 o'clock.
Are you cool with that, Mr. Lloyd?
Yes.
Ms. Nunez?
Yes.
All right, so we're back on the record. I'd be happy to hear your, rebuttal, Mr. Shaughnessy.
Thank you, Your Honor. Again, if it would please the court, I'd just like to briefly touch on a few subjects. Regarding causation, Your Honor, and I would just direct you to OJI 417.23. Cause, the state charges that an act or failure to act of the defendant caused death. Cause is an essential element of the offense. Cause is an act or failure to act which in a natural and continuous sequence directly produces the death and without which it would not have occurred. So what cause says, Your Honor, is that you have to commit an act or failure to act, and without your act, the death would not have occurred. Well, the state certainly has not given you, even in the light most favorable to the state at this stage, evidence that without Mr. Brelo's, Officer Brelo's actions, that the deaths would have occurred. They have not given you that sufficient evidence.
Would not have occurred.
Correct. If you took, here, they haven't given you the causation evidence. They could say, put up all kinds of charts and forms and say, well, this is a downward trajectory. You know what the trajectory evidence is. It's not there. A lot of it can go right to left, or 9 o'clock to 3 o'clock, or 10 o'clock to 2 o'clock, but it's not going up or down.
But isn't that a distinctly factual argument for closing argument?
Okay. But I'm just trying to point out, again, Your Honor, perhaps it's not appropriate at Rule 29, but I think it is, because even taking the evidence in the light most favorable to the state of Ohio, they haven't given you that causation evidence. They haven't, he can say, I think it might have, or it's steep, so it had to have, but he hasn't given you that evidence. And they haven't given it to you through any expert. They haven't identified the pellets or the casings. Judge, I would also, in my brief ability to start to look at the cases in their brief, they say, well, these are these other cases where other people shot. Well, none of those other cases involve justification of other shooters. None of those cases involve the unique circumstance here of them claiming that there were other justified shooters. All of those cases deal with perhaps the idea that we get two people going to rob a bank, we both shoot the teller dies, it doesn't matter if it was you or I. Okay? And this is a distinctly different situation. So again, Judge, even in the light most favorable state, their cases don't support their causation requirement. The OJI instruction doesn't support their causation requirement, and their facts don't support their causation requirement. Now, Judge, we talked about this constitutional probable cause under the Fourth Amendment, under White, under Garner. And in a light most favorable to the state of Ohio, with everything you've heard, even taking everything they presented for the last 2 weeks or so, and give it all to them in a light most favorable to them, Officer Brelo still had probable cause to believe that he was in danger, other officers were in danger, or members of the public were in danger. And when I say that, let's take the evidence that they presented to you in a light most favorable to the state of Ohio. Officer Dan hears a shot. He believes he's being fired upon. A chase ensues. It's 22 minutes. It's 20-some miles. It involves many, many cars. And again, those policy procedures do not negate the Fourth Amendment probable cause. So what happens? 20 minutes. Lights flashing. Repeated radio calls of, she's pointing a gun. She's reloading the gun. They pointed a gun at us. So it's all those, that's the light most favorable to the state, Judge. That's the evidence that came from the government, not from the defense. That this 22-mile chase goes on. That numerous, we know this is relevant under White, numerous crimes were committed by the folks in the Malibu. And those are all things taken in a light most favorable to the state that lead up to the end of this. And the probable cause. Malibu's hit other cars. I mean, that isn't a fact that we can not take in a light most favorable to the state or take in a light most favorable to the state. It's a fact. So all of the things that occur, and all of the things that occur at the schoolyard, all of the things that went into every officer's mind as they were in this pursuit, as testified to by Katsaris and as testified to by Agent Soraya. And as testified to by Agent Soraya in all of the interviews that he did. So let's take all of that in the light most favorable to the state, because they're the only ones that presented witnesses. Take it all in the light most favorable to them. And these officers were scared, they were petrified, they thought they were going to die, they thought that they were being shot at, they thought that they were in imminent danger of bodily harm and death. And this is taking it all in the light most favorable to the government. And then what happens? The car gets into the Heritage Middle School, and it spins around, it jumps an island, it's not trapped, that harm isn't over, and this is taking it in the light most favorable to them. It's not over. It jumps the curb. It tries to run over Officer Diaz and he fires shots. Okay? So that's in a light most favorable to the state because that's all we got. So let's say that's it and we agree with it. Then the car comes down past how many police cars and then rams into 238. Take that in evidence in a light most favorable to the government. The car is streaming down and it rams into 238 and shots begin to ring out. Now let's take that evidence in a light most favorable to the state of Ohio. Because you asked Officer Agent Soraya, in that type of shooting, does it appear that those shots could be coming from the Malibu? He says, absolutely. It's all over the place. The shots are firing. The car is still in drive. Take that in the light most favorable to the state. Did the probable cause cease there? That car could cause physical harm or death to somebody? It was still in drive. It's against the zone car 238. And when you go back and you look at Plumoff, and you look at some of these other decisions, In those cases, the car's even reversing, and they're allowed to continue under the Fourth Amendment the use of deadly force. But here the car hasn't stopped. It's still there. It's in drive. Take the evidence in the light most favorable to the state. Mr. Bell says he can see in there and they're still moving. Well, read the decisions, because if we're going to take it in the light most favorable to the state of Ohio, and officers can look in there and see these folks still moving, they're still a threat. There's still probable cause in a light most favorable to the state of Ohio that they're going to continue to cause serious physical harm to officers and others. And there's no inclination, there's no indication that they wouldn't get through those two cars and go back out on the road. And remember, take it to the light most favorable to the state of Ohio. How many traffic violations? Hundreds of miles an hour. Drove through Happy's Pizza's parking lot. Again, putting people and officers in danger. So take all that in the light most favorable to the state of Ohio. When does the probable cause cease? Mr. Bell, in talking about the firearm specifications, wants to say at some point Officer Brelo left his scope as an officer and was no longer acting as an officer. Even in the light most favorable to the state of Ohio, Judge, when did that happen? After 22 minutes, flashing lights, sirens, chase, multiple felonies by the folks in the Malibu in less than 2.6 seconds? So, Judge, even taking all of this in the light most favorable to the state of Ohio, you can find, take every inference in their favor, and you can still find that Officer Brelo was never stripped of his probable cause, that he and other officers were in danger of great bodily harm or death. The car's still moving, the hands haven't come out, there's no surrender, the car is in gear, and again, when we're taking the evidence in the light most favorable to the state of Ohio, and we're going to strip this police officer of his probable cause under the Fourth Amendment, you've got less than 2.6 seconds. So, Judge, I do think that at this stage, you can direct this verdict based on all of the evidence, based on the totality of the evidence, based on the totality of the circumstances, even taking it in a light most favorable to the state of Ohio. And I think when you look at Plumoff, and you look at White closely, and you look at Gardner, that it's very appropriate that that be done at this stage. Thank you.
Thank you, Mr. Shaughnessy. The motions, I do classify them as plural because there is the alternative motion to dismiss the suspects only, are marked as heard and submitted, and we're off the record. Ms. Barnhill, everything you've offered that is in evidence, well, let me ask Rob. My inclination is to ask her to hold on to it, but you tell me.
That's fine.
All right, so can you maintain the record evidence by way of exhibits, and then if these motions are denied and deliberations have to be undertaken, we can deal with them then?
Of course, Your Honor.
Also, I've asked you, if you can, to get me everything that can be done by email, and you're willing to do that?
Yes, Your Honor. It will probably be a
Or
drive.
okay.
Would you like the exhibit list as well?
Just please, and just make sure your opponent is. If you're going to give me a flash drive, I guess let them review it first to be sure that only things that have been admitted are on there. You
Great.
probably don't, or if it's easy for you, make 2 copies and give them a flash drive. But the point is, I'm going to rely on the proponent of the exhibits that have been admitted so far to maintain them at least until we're certainly done. Is there something you want to say?
Yes, Judge, just wondering about the schedule next week, what witnesses will be called up or due up on Monday, Tuesday.
Well, let's assume, Mr. D'Angelo, these motions are denied, which you already know you may not learn if that's going to happen until Monday morning. Who would you propose for Monday?
Your Honor, I believe that Dr. Michael will be available, I think he's arriving Sunday, I confirm that, but I believe it will be Dr. Michael, Martini, Stutzman, Martinelli may not be available to Tuesday, however, he may be available on Monday. Johnson, he may not be available until Wednesday. And Dr. Rowe would be Wednesday. And Dr. Posey, unless I discover something to the contrary, despite my arm twisting, may not be available until Thursday. And he would then be the last witness.
Are you telling me, though, that you think 3 or 4 could get done on Monday, leaving us with nobody available for Tuesday?
Unless Martinelli's here, then we can always do him as well.
Well, I will say this, because of my own personal matters, I don't know that I'm going to be able to go as late next week. This is all under the assumption that we will be in trial, as we have been going. I might have to break it for. But the point is, you more or less that order, but you may have to ask for a one-day continuance at some point to get your next available witness.
Yes, I think the only one I'm not worried about going to be here is Dr. Posey. He's was in Ohio. He's now in Texas, and he's there I think Monday, Tuesday, and Wednesday of next week. So the earliest I think he'll be available to testify is Thursday. And Dr. Rowe she was available Wednesday to testify, and I think that's the same day for Dr. Johnson. And then we can complete the others either Monday or certainly Monday and Tuesday.
Are they? Some of these are out of town, as I recall. Are they flying in probably Sunday or so? Or?
Yes, I think I haven't had a chance to look at this morning yet, Your Honor, but it's my understanding that Martinelli, Martini, and Stutchman are flying in late Sunday. And I'm not sure about Dr. Michael. I haven't spoken to him yet, but I don't think there's an issue for him to fly in on Sunday. And as I mentioned, Martini. Martini's coming in on Sunday as well.
Does that answer your question, Mr. Bell?
It does, Your Honor. Thank you very much.
Any kind of other miscellaneous? It's by no means my preference then to take off more days next week, but I will say tomorrow is, for my reasons, I'm getting stuff done in the morning and I have something I get to do in the afternoon, and Friday afternoon is for my reasons. So if it comes time when he requests a 1 or 2 day continuance because he doesn't have the next available witness, you are welcome to object. You're welcome not to. If you do,
We're not going to object, Judge.
It'll probably be overruled. I think that's all I have then.
And that's it, Your Honor. And again, nothing, no criticism intended here, but we're not going to be cutting envelopes and looking at numbers and all that. So we're going to move through these witnesses, at least from the defense side.
Usually when you start out by saying no criticism intended, you...
Right, but I got to give my little shots.
You know how I was going to say.
But I mean, we're not going to be, I think it's just not going to be the same like the medical examiners and some of the other witnesses where they're, fact intensive that way. So I just think that I would love, if it were me, I'd have them all here Sunday and we'd run them through, and if we're done Monday night or Tuesday afternoon, I'd be the happiest person in the court. So I'm doing everything I can to get to here as quickly as I can.
No, I'm not suggesting it's somehow your fault if we do have to take another break next week. But
that would be it, Your
if
Honor.
I thought it was, then I wouldn't grant the continuance. So sometimes these people are not available. If there is going to be a closing argument, it's going to be to the parties' wishes about how to do it. For example, in opening, the state divided it by 3. You're welcome to divide it by 3. You're welcome to have one person do opening and rebuttal. You're welcome to divide it by 3, by 6. I think the rebuttal should be confined probably to one person. But even that, as long as it's not out of hand, you might want to say so-and-so is going to rebut certain contentions and so-and-so will rebut others. And the same with the defense. You're welcome if you want. I know you only have one argument, but you're welcome to split it up 3 ways. I'm not saying you're encouraged to do so, but those rules aren't hard and fast, and there's a lot of considerations in this case. So if it's more sensible to have certain lawyers addressing certain questions and certain proof or lack of proof, figure out how you want to do it, and I'm not going to have a problem with it. So.
Any rough parameters, any time limits, Your Honor, or just...
When my head starts pulling a Ronald Reagan, you might consider that you're probably not having a great effect.
Some reasonable...
No, I'm not going to have a time limit. This isn't going to be William Jennings Bryan speaking for 12 hours at a political convention. I gather there's still no chance of a plea bargain? Semi-facetious. Well, I shouldn't say semi. I should say entirely facetious. Thank you. See you.